Welcome back from a brief lunch respite. When we suspended our proceedings this morning, the member for Bain and Grandstand rose to his feet to initiate debate by way of second reading in committal, the bail amendment bill. The chair will recognize the honorable member for Bain and Grandstand. If the member is so prepared, the member yields. The chair recognizes the honorable member for Fox Hill.
Yes, Mr. Speaker, I just wanted to point out to the House that during the time that the exchanges were taking place this morning, there was some information being posted on social media about some actions taken by me in my official capacity as Minister of Immigration to block off the access to the House of Assembly and the roads here in retaliation for what was described as some fiasco or other. I just want to say, first of all, I know people have their talking points, but there is no Cuban fiasco. That's the first thing. Secondly, no action was taken by me in any way, shape, or form with regard to operational matters dealing with the Department of Immigration. I don't interfere with them. They don't ask me in advance. I have no idea what these people would be saying. And I just want to disabuse the individual and the public of any such notion this morning that there was some specific action ordered by me in response to anything that has happened over the past few months or days in connection with this matter. Thank you.
Thank you, honorable member. Member for Bain and Grandstand.
Mr. Speaker, I've stood to move the bill for an act to amend the Bail Act. Bill for an act to amend the Bail Act. Mr. Speaker, the act is being amended by the insertion of two new sections, 12A and 12B, into Chapter 103. And these brief amendments will have the effect of making violations of bail conditions a criminal offense. As you know, sir, bail is the temporary release of an accused person in exchange for security given for the due appearance of the accused. This is because the presumption of innocence requires that unless lawful conditions are met, an accused may be released on bail, pending the trial of the charges of which he might be accused. All too frequently, persons released on bail may be charged with further offenses or themselves become victims of crime. There's a view held in our country today, Mr. Speaker, that there are situations where accused persons are permitted bail by magistrates or judges in instances when the general public or any individual member of the public may feel that they should not be on bail for one reason or another. And in the country, this question of bail has become a very controversial subject. Indeed, as Minister of National Security, in answering a question raised here by members opposite on one occasion about bail, I made remarks which were considered by some lawyers as contemptuous of the court. But to be honest with you, it's very, very difficult for me, with the responsibilities that I have, Mr. Speaker, as Minister of National Security, not to be very concerned about when bail is administered to certain people before certain charges. Nevertheless, Mr. Speaker, in a time when we have many serious crimes being committed, homicides, murders, manslaughter, rape, armed robbery, we all are aware, and we all know that as a result of the volume of crimes that we've had, particularly in New Providence and to a less extent Grand Bahama, the whole country is speaking about the fear of crime. And people are becoming more and more fearful because not infrequently persons who have been charged with a crime and given bail commit other crimes while they are on bail. One of the presumptions when an accused is given bail is that during the period of the bail and until their trial is held, that they not commit another crime. But from where I sit, this is not an infrequent occasion. Indeed, many people who commit the most serious of crimes seem to recommit or reoffend, Mr. Speaker, before they've had time to have a trial. And the consequences of that are very frightening. Indeed, so much so that the public's perception now is that the majority of perpetrators who commit crimes or who commit offenses are repeat offenders or persons who are out on bail. Repeat offenders in the sense that they may have committed that crime before and have been charged and convicted and perhaps served time or served whatever the penalty was. Or they may have committed an offense, or at least having been charged with an offense, and while they are awaiting their trial, being charged with committing a second or a third crime. And I can tell you that there are persons who are in our community who have been charged with murder, not one, but charged with murder and charged a second time with a separate murder. So we have some people who are walking around who are on bail, or who are on bail for 2 murders, or 2 or 3 armed robberies. And these armed robberies are usually robberies with guns. In some cases, people have been injured, and they go to court, they are remanded, many are given bail, and they commit again. This is part of the creation of the fear that our society is experiencing. In the average case, let's not talk about a very serious crime, but in the average case, when an offender is given bail, the magistrate or the judge may impose some conditions. To give you bail, and the conditions are that you must report to the police station every Friday afternoon before 6 o'clock. or you must report 3 times a week, Monday, Wednesday, and Friday, with a time frame. Or there may be a curfew. You must not be out on the streets after 9 o'clock at night, or between 9 in the night and 6 a.m. in the morning. That's a condition. Free to go, you're free to go to work, you're free to move about, but once 9 o'clock comes, you're to be indoors and to stay indoors until 6 in the morning, maybe at a specific place, a specific location. Or there are certain areas in which you must not go. You must not go into Pinewood Gardens, or you must not go into Nassau Village. Those are conditions which, if you violate them, and you go in spite of the conditions which were given to you, nowadays I'm not sure what necessarily happens to you. But what this law is doing, this amendment to the Bail Act is doing, is it's creating the violation of conditions to be an offense. An offense which on summary conviction exposes you to, on being found guilty, to a fine not exceeding $50,000, not 5,000, not 15, 50, up to $50,000. Now this is not a mandatory $50,000, because the judges have indicated to us on more than one occasion that they are not likely to be bound by mandatory penalties. But the law, the amendment says that you can be fined up to $50,000 and 5 years in prison for the violation of bail conditions. These conditions, as I indicated, may be sometimes difficult for an offender to satisfy. For example, a lot of people today are concerned that restrictions don't prevent them from being able to get a job and sustain a job and maintain a job. But if you have a curfew that says you must be in between 9 p.m. and 6 a.m., and you work in the hotels or you work in a nightclub, you're gonna have a problem, because those hours are hours when people who work nights are working. Unless your attorney asks for special consideration to be given so that the conditions are not inconsistent with your carrying out some lawful tasks. Condition may be that you're not to use alcohol or be found with an illegal weapon or not commit other crimes. And one of the problems we have with many of our young offenders is that they do use drugs. They do use, especially marijuana. Some of them use other drugs. And so if conditions arise in which they are found in possession of a weapon, or if they are found in possession of drugs, if they do not follow the curfew, in certain instances, for example, they may be ordered not to make contact with someone who may have been the victim, or indeed someone who may be a witness. Because we know in this here town, right now, witness tampering is becoming more and more prevalent in the court system. We are getting requests from more and more persons who are witnesses to criminal activities seeking protection from the police because they've been threatened by perpetrators who are on bail, or may not be on bail, or just may be associates of perpetrators. And so, if one is found guilty of one of these violations, they can be charged with violation of conditions of bail as an offense. It's a strict liability offense. So the prosecution, as I understand it, don't have to be able to give a reason. But I hope that the seconder will speak to those legal matters with which I am not familiar. Mr. Speaker, one of the conditions that are violated not infrequently is that which requires offenders to report to a police station by a particular time. It's one that really hasn't been very well controlled by those who work in police stations or who are officers in charge of police stations. Because, and sometimes the problem is a communication problem. The judge or the magistrate sets a condition which says you must report to the police station on whatever days, at whatever time, or before whatever time, and the police station may not have a record of it. So we are seeking now to ensure that our communication system between the courts, between the prison, between the Attorney General's office and the prosecution, to ensure that these conditions are known to the authorities when they are invoked. Mr. Speaker, this bail thing is necessary. If for no other reason that in the Bahamas, if for no other reason that our prison, which was all of the prisons together, which were built, well, maximum security, which was built for 250 people, has over 800 people in it. And the prison system, in prison today, we are now over 16,000. We've been around 15,000 plus for almost 2 or 3 years, but yesterday there were 1,658 inmates in the prison, 42% or so of whom haven't been convicted of any crime. They're there on remand. It's not 16,000, 1,600. 1,000.
Is it 70% of 80%?
Huh? No.
What percentage?
42%. Around 42%. That could be a little bit higher, almost 50%, or it could be a little bit lower. One of the reasons why we are going to develop a parole and probation system is so that we can create conditions under which persons don't have to be incarcerated for certain crimes. One of the principal ones are these drug-related crimes, this possession of small amounts of marijuana, for example, as an example. Vagrancy. We are seeking to create alternative sentencing for persons. And, you know, I sometimes feel like I'm being schizophrenic because on the one hand, I'm complaining about people getting bail, and on the other hand, I'm trying to help people to get bail, except that we're dealing with two different categories of person. Because we cannot go on jailing all of our young men, or many of our young men, or as many of our young men as we are doing, without seeking to find ways to reform them and transform them. An additional problem that we have is that when people violate their bail, very often people who know them and know they're violating their bail are reluctant to report them for the bail violation. And people who post bonds for them, their charges, are often you can't find the accused when time comes for a trial, and the people who put up the surety don't know where they are. And I think this sometimes doesn't go punished. But anybody who stands as a surety for somebody receiving bail, they have a very serious responsibility. Now, we have some people who frequent our courts who are professional. I call them with a small p, shorters. And they stand bail for Tom, Dick, or Harry. And some of them use the same piece of property to stand bail for a number of different persons. Sorry? Some big lawyers? Oh. They do this because this is a way for them to earn money. But the truth of the matter is that I don't think it's legal. Because if you put a bill for one person with a piece of property, you can't do the same for others unless the property can cover. Well, I wouldn't go there. Anyway, specifically, this is the practice that I would like to see stopped. People who are concerned about bail feel that, for example, some people recommend that people who do gun crimes, who are found in possession of an illegal weapon, or who use an illegal weapon and are charged for it, should not be entitled to bail. In fact, that's part of the view that is emerging among us today with all these very serious crimes. There's no bail, but our judges have told us that they will not be stopped from using their discretion. I was reading yesterday that, well, we were told as a result of a Privy Council decision that it was reasonable to hold somebody without bail for up to 2 years who's charged with a serious crime like murder. But what we found happening in our country was that people were getting bail for much less times than that. And in having discussions about it, it turned out that there was a period, which I hope is past us now, when we could not guarantee a trial within 2 years because of the backlog of cases. And it appeared to me that a decision was being made that if there's no point in me keeping you in prison for up to 2 years, when the 2 years comes, then it wouldn't be possible to try you even then. So what came to my attention was the fact that persons were being given bail for serious crimes like murder, like rape, like armed robbery, for much shorter periods of time. But then something else came to my attention, and that was that particularly with the violent crimes, in the year 2014, I think it was when we really noticed it, that many of these people who were given bail were victims of a serious crime themselves. I think it was in the year 2014. Well, I think the House is aware that some 5 years ago, the then government instituted electronic bracelets, ankle bracelets, for tracking offenders. And in most administrations that I've looked at, these tracking bracelets were used, where they were used for pre-trial cases, they tended to be used in low-risk cases in order to enable those persons not to have to be incarcerated. But in our country, when the practice was introduced, and it still is now, the persons who were fitted with electronic ankle bracelets were people who committed serious crimes, like the homicides and the armed robberies. And that is still the case today. And over the past years, we've had, on average, about 350 to 400 people fitted with an ankle bracelet at any one time. Right now, we have some 360 persons who are wearing ankle bracelets. These ankle bracelets are extremely useful if operated properly, if the monitoring is proper, in the sense that they are to be worn all the time. You are not to tamper with them to try to take them off. They have a device, they have a battery which needs to be charged. You need to charge it. If you are not charging it, those who are monitoring you will notice when the battery is going down. They'll inform you that the battery is going down. There's an alarm on the bracelet, and the people doing the monitoring will inform you, and they can speak to you and tell you what's going on and ask you to charge your battery. And if you do not charge your battery, there's an opportunity for them to notify the police, who will come and look for you and find you and either you charge the battery or they'll take you into custody for what now would be a violation of your bail. Well, we found, Mr. Speaker, in 2014 that during that year, there were known to us 30 persons who were on bail and wearing an electronic monitor who suffered, Mr. Speaker, who were murdered. So and the investigation of these cases suggested that these were mainly retaliation cases, where the person who themselves had committed one of these crimes, murder or some form of a violent crime, and the investigation showed that some of these appeared to be killed by gang associates or people from gangs not theirs. Some of them appeared to be due to family associates. I think I might have told this story here before, but it got so bad, I guess, or interesting that one offender who was in prison awaiting trial was told one day that somebody paid his bill for him to come out of prison. And he wanted to know who this was because he didn't know that anybody would pay a bill for him. He didn't expect it. And when he inquired, he found out that the person who was paying his bill was some relative of the person he was in prison charged with offending. And so he refused to accept the offer to pay his bill because he was... Huh? He was a smart fellow, yeah. But the point I want to make is we've gotten to the stage in our country where people would do that kind of thing, something that we would not have expected earlier. Last year, by the first week in April, I don't have figures beyond that, by the first week in April last year, we had 15 persons who had been murdered in the first three months on a bit, who were wearing an ankle bracelet at the time. So wearing the ankle bracelet don't kill you. But being on bail is a risky situation for many of these young people who are involved in this type of crime. It's amazing how often people violate their bail conditions nonetheless. I have just a sampling of a report of some people who were given bail in the second week of this month. And you know, it's interesting But a lot of people have no conditions. For example, a young man in Abaco tried with shop breaking and stealing. They fitted him with a bracelet, but they didn't give him any conditions. The bracelet wasn't charged when they gave it to him. And they couldn't find him to get him to charge it. It took them several days before they found him. Last week we had 358 active offenders on electronic monitoring. 10 of them were new offenders to the program. And 6 of them with a bracelet, 1 charged with threats of death, 1 charged with armed robbery, stealing and receiving, 2 charged with house breaking, 3 charged with house breaking, 1 charged with possession of dangerous drugs with intent to supply, and about 2 or 3 of them were charged, the conditions were to report to the police station 2 days a week. But in more than 6 out of the 10 had no conditions imposed. I guess the view is that if you have an ankle bracelet, you don't have to have a condition. But my experience with the ankle bracelets is that people who wear them, for some of them it seems to be a fashion statement. So,
Interesting times.
Mr. Speaker, I have here a man who's charged with 7 counts of armed robbery, 4 counts of attempted robbery, and 1 count of attempted murder. And he was put on an ankle bracelet, and the next thing, he absconded. Nobody could find him. It took them, they did find him eventually. But the point I'm trying to make is that even though you might be fitted with a bracelet, it should make it easy to find you if you are still in the jurisdiction. In fact, even if you're not in the jurisdiction, because the devices are equipped with GFS, and you know we've had people who have been found in Canada who's supposed to be wearing ankle bracelets.
You're checking with the manufacturer. Yeah. Yeah.
So, ladies and gentlemen, sorry, Mr. Speaker. What we are seeking to do here is to discourage persons who are on bail from reoffending in the first place, from reoffending. Because if you reoffend today, or before this law passes, you will be charged with a minor offense. Or you'll only be charged with the reoffense. But once this law comes into effect, if you reoffend, you'll be charged with the crime that you committed, and you'll also be charged with reoffending. And if you are charged with reoffending and found guilty, you face a very serious penalty, $50,000 up to, or 5 years in prison. And really, to some extent, that is more than offenders are given today for being found with illegal weapons and illegal ammunition. So, Mr. Speaker, what I'm hoping is that we can get support for this legislation. We're in the third month, finishing the third month of February. The statistics show something of a slowdown in these major violent crimes, but there's no reason for us to ignore the sense of safety and security which eludes many of our citizens. The Commissioner of Police has released his plan for the year, policing plan, and I shall be coming back to Parliament within a couple of weeks with some major matters which we are introducing. Upgrades in the human resources and the force, provision of technology that can assist us in our work. I want to talk to members about some of the things that we have under consideration, which include the possible imposition of curfews in specific places for specific reasons, the use of the Royal Bahamas Defense Force in association with the police in certain specific situations, the creation of a National Citizen Security Council made up of members of the private sector to work with us and with the police in developing crime-free communities, and a number of other issues which I'll bring to the table in due course. But today, the hope is that we will get support for making the violation of bail conditions a criminal offense, subject to the possibility of a fine of up to $50,000 and 5 years in prison. Be interested to hear the response of members opposite to this, in the hope that we can, in the hope that we can work together to rid our country of the level of serious violent crimes that we've been subjected to over the past year. Thank you, Mr. Speaker.
Thank you, honorable member. Do we have a seconder? Chair recognizes the honorable member for South and Central Eleuthero.
Good afternoon, Mr. Speaker. Mr. Speaker, it is my privilege and honor to rise once again for and on behalf of the good people of Central and South Eleuthero. Unlike New Providence, the community that I represent is pretty much crime-free. But we are affected by the news of crime and violent crime. In fact, listening to the radio, the very psyche of the Bahamian public has been called into question as we seem to exceed negatively our worst expectations of ourselves. And having said that, Mr. Speaker, it is to be noted that it is tempting amidst this melee to lose sight of some of the successes which we have in fact achieved in the last 4 years. And I wish to start my contribution by paying tribute to the good men and women who work at the Attorney General's office and who have played a magnificent role in achieving the successes which the Swift Justice Initiative of this administration has achieved. We now have 10 criminal courts operating at the same time, 5 days a week, 52 weeks in the year. We have 5 new state-of-the-art, technologically equipped courts in the Swift Justice program. We have passed legislation in this House expanding the possible number of Supreme Court judges to 20. We have introduced video conferencing capacity in the Supreme Courts and in the Magistrates Court, so that now, 4 years about to transpire in May of this year, witnesses from the Family Islands and abroad do not necessarily have to travel to New Providence or Freeport to give evidence. And this may seem a small issue, but it is in fact a cost-saving device which has enabled resources which were otherwise used for spending on travel and accommodation to be defrayed elsewhere. And that has been very helpful. It also enables courts to more confidently schedule trials, because the person who is abroad can book to go into the conferencing center. That is prearranged, and the vagaries of snowstorms and weather are obviated, and by and large, the system improves. We've also amended our laws to allow for video conferencing and digital evidence of tracking on ankle bracelets and CCTVs. We have brought our legislative program to a point where technology can be properly utilized to make our courts most efficient and to enable trials to proceed at a pace, which hitherto we had not witnessed. And so, Mr. Speaker, as I speak today, I'm able to report that in 2012, when we took office, we met a court system which disposed of 118 trials during a calendar year. In 2015, that number is now at 228 trials for the calendar year. Mr. Speaker, that represents almost a doubling of output in the judicial system. And it has happened under the watch of the Progressive Liberal Party. In fact, Mr. Speaker, we moved the rate of convictions from 31% in 2012 to 63% this year. In 2012, no murder trials were concluded within 1 year of a person being charged. In 2015, 7 murder trials were concluded within 1 year of the persons being charged. Mr. Speaker, in 2012, when we took office, the average time for the presentation of a voluntary bill of indictment was 344 days. That is to say, it took almost a full year of a person being presented before the magistrate to be given the formal charges for the information that is being laid in the Supreme Court. In 2015, that time span has been reduced to 80 days, and it is being further reduced by policies which are being implemented in the Attorney General's office. And while we were doing this, Mr. Speaker, we have set the stage for Public Defender's Office, identifying office space and recruiting persons to fill this very, very important institution. As if that were not enough, we have changed the law relating to the selection of jurors, and as a result of the modernization of our laws, there are fewer lost court days due to the inability of the court to impanel a jury. We have modernized the court reporting unit, giving the court reporters the technological tools to efficiently carry out their very important function. We now have the capacity to download court reports daily to an e-file on the court reporting unit database, rather than the old system we met in place in 2012 of reporters taking their work home on CDs and drum drives. And the insecurity introduced to the system by that practice, because these are public records which ought to be securely kept in the public domain. We now keep the reports safely in a secure database. And we are moving in the direction, Mr. Speaker, to obtain transcripts online. Mr. Speaker, this is mind-moving development. It isn't the type of development that gets the headlines, but it is important to note, because as we reduce the time it takes to prosecute matters before the Supreme Court, a lot of the problems which we now face with respect to persons, first of all, getting bail, and secondly, of persons being out on bail for protracted periods of time, those dangers are being addressed on a daily basis by an administration which has kept crime and crime fighting as one of its signal objectives, and we make no apology for having done so. Mr. Speaker, the witness care unit has been expanded at the Attorney General's office. Witnesses are contacted earlier, and contacts are maintained. Witnesses are advised early about witness anonymity and witness care. So that this government has, for the last 3 years and 10 months, paid specific attention to many of the problems which are weaknesses at the systemic level. In spite of these things that have happened, the devil has been busy, and criminals have been active in the work that they do. In spite of what we have done, there were 158 murders last year. In spite of efforts of the government, persons have continued to break the law. A number of them, as has been pointed out by Bain and Grantstown, have been persons who have been released on bail by the courts. And the courts grant bail because it's an entitlement, particularly where a person cannot be tried within a reasonable time. In the 27 years that I've been called to the bar, the first time I heard about conditions being imposed for ankle bracelet wearers was just now. But it makes sense. And I think Grantstown and Baintown would be surprised to learn that I can't remember a case in which anyone was specifically ordered by a judge to charge the batteries of the ankle bracelet and to keep it functional. And some of the things that we are talking about need to be standardized, and judges need to, it needs to be brought to the attention of judges that certain things are going to need to be considered for the purpose of making orders. Because if you're going to enable a person to get bail by saying you will wear an ankle bracelet, one would think you don't need to actually tell them you got to keep it on or working. But the reality is the offense that we are creating presupposes that express conditions have in fact been articulated and explained to the persons who are being admitted to bail. In some instances, judges don't even bother to tell the person who is being admitted to bail that you have to be of good behavior. It's assumed that they understand that. But if they're going to be charged with the offense of breaching a condition, the condition will have to be articulated and expressly put forward in the order which the judge is making. It is easy to cast aspersions on public servants, including judges, I suppose. The reality is that what we are attempting to do is to make our community safer. This bill, when enacted, is intended to be an additional deterrent to persons who have been given the ability to be free, even though they may be perceived by some in law enforcement as being dangerous. It may be argued that already if a person commits another offense while on bail, that matter ought properly to be brought to the attention of the court which granted him bail or her bail, and ought also to be brought to the attention of the court before whom he or she is being charged with the new offense. In many, many cases, unfortunately, neither court is informed either of the conditions of bail that pre-existed the new matter, or indeed, in many instances, rather, the pre-existing offense, the matter that is already before the court, is not even brought to the attention of the new magistrate. These are things which, unfortunately, lie at the feet of the Attorney General's office and the Commissioner of Police. I say both of those offices for this reason. In the Supreme Court, the Attorney General's office runs the prosecutorial service on behalf of the Crown. In the Magistrates' Court, that function has been delegated to police prosecutors. And I could say something about that, but I won't, for the purposes of this debate, get into that. We need to tighten up our prosecutorial services. We have been making strides in ensuring that the database is established. When we came into office, for instance, a file relating to Tom Jones or John Doe would be all over the place. You would have a bail file for every single bail application he did. So if he had 10 bail applications, there's not one file. There are 10. So you have to find in that system all these different documentations. And it becomes an administrative nightmare to actually know what is going on in a particular matter. Well, the Swift Justice Program brought all of these files into one file. And as a result of it, in the meetings which are held on a weekly basis, you are able to see what is happening in a particular matter. That information is not intended to be just kept for the purpose of keeping it. It is to enable the prosecution personnel to monitor what is going on. So when a name crops back up, you should be able to go into the database and say, well, look, he's already charged before Justice Smith or Jones with these offenses. This is a similar offense. We should bring this to the attention of Justice Jones. And as we get more efficient, legislation such as this will become even more of a deterrent, because now the system will be looking for specific information which is readily available to it. Mr. Speaker, having said that, it is my fervent hope that when this bill is passed, that we do not introduce a level of laziness in ignoring the steps that need to be taken to draw to the attention of the court breaches of bail conditions. And it is highly important that that's done. It's one thing to say that a judge, having heard it, takes a decision to continue bail. And a judge might do that. There may be circumstances where the breach is so trivial that revoking bail is not regarded as appropriate. And for instance, that might occur where a person lives in a family island and he has a requirement to report to the Governor's Harbor Police Station by 6 o'clock in the evening each day. But one day he has to come to Nassau to go to hospital. So instead of reporting in Governor's Harbor, he goes to the East Street Police Station, reports in, and explains why he is doing it. The officer calls the office, the police station in Governor's, and indicates that he has reported, which is really the requirement. In substance, he has obeyed his condition, but there is a difference. And to an extent, he has breached his condition because he has not reported at the place where he is required to report. I would hate to think that in those circumstances, an attorney general would be so unreasonable as to charge a person with a breach of this section. And that really is the caveat that I bring to the House's attention, that there are instances, because of our geography, where persons may well be found to be in strict terms in breach of their condition. But if the substance of the condition has been satisfied, care must be made by the authorities to ensure that the legislation is not seen as a vehicle of abuse. And the temptation to do that could be there, because you may have a guy who is in fact regarded by the police as a very, very dangerous and bad person. And well, I don't know about that, but in those circumstances, the temptation to be capricious with respect to that person is great. I'm not sure how we can cure that in this bill, but I draw that to the House's attention. Mr. Speaker, I do not propose to draw this out. And Bain and Grantstown asked me to discuss mens rea, I suppose. Mens rea, guilty intent. In criminal law, there are two different elements of an offense that are, broadly speaking, always present. One is the actus reus, which is the act that you are not to do. And the mens rea is the guilty intent. That is the mental frame of mind that a person must have in order to be found guilty of the offense. Strict liability offenses are an exception to this general rule of analysis of criminal law. In strict liability offenses, the Crown need only prove that the offense that has the act that is prohibited has actually been committed by the person. And the mental intent is, to all intents and purposes, irrelevant. In this instance, however, the dangers which are associated with strict liability offenses may be countermanded by the extreme danger which persons who have been admitted to bail have either subjected themselves to or subjected others to. We have the complaints of persons committing murder and other serious offenses while on bail. We have the reports of persons who are actually murdered while on bail. In fact, a number of years ago, I was contacted by someone to act on behalf of someone else who had been charged with the murder of one of their kinsmen. At the time, I didn't know, and I checked with the accused. He said, well, I don't have any money to pay you, and I don't know who would have sent you. So I said, well, who do you know so-and-so? And he says, do you know who is alleged that I have killed? I said, no. He says, well, that's his cousin. So I went back to the gentleman. I said to him that, you know, I'm not an agent of this sort of stuff. You need to find somebody else. But these things happen. And the thirst for revenge has grown by leaps and bounds over the years, while the perception arose that we weren't serious about fighting the backlog. But this government is serious about fighting the backlog. We are serious about fighting crime. We have done things, some of which have worked, and we ask the public to continue their confidence in us while we continue to do the difficult things which will bring us a safer society and restore the tranquility that we seemingly have lost. God bless the Commonwealth of the Bahamas.
Thank you, honorable member. It has been moved and seconded that the following bill be read a second time and committed. A bill for an act to amend the Bail Act. As many? Chair recognizes the honorable member for Montague.
Thank you, Mr. Speaker. Thank you, Mr. Speaker. Mr. Speaker, this bill that we're debating is another clear example of window dressing by this government to make it appear that they are intent on being tough on crime. But when you when you review the bill, you see that it is really nothing of the sort. If you look at the present Bail Act, there's already an offense under the Act for failing to appear in breach of a condition of bail. So under Section 11 of the Act, you are liable on conviction to be sentenced to imprisonment for a term of 2 years. In addition, under Section 12 of the Act, where someone is released on bail, there are offenses which can be committed if the person, in the view of a police officer, is likely to abscond or likely to breach the terms of the conditions of his bail, that he can be arrested, taken before a magistrate. And the magistrate can then review the terms on which bail was granted. So that under subsection 5 of section 12, it's provided that subject to paragraphs A and F of Part A of the first schedule, where a magistrate before whom a person is brought under section 4 is of the opinion that the person is not likely to surrender to custody, has committed another offense, or has broken or is likely to break any condition of his bail, the magistrate may, subject to subsection 6, remand him in custody or commit him to custody as the case may be, require, or alternatively grant him bail subject to the same or different terms. So at present, this person can be brought back before the magistrate. He's breached a condition which was attached to his bail, brought before the magistrate. And the magistrate then has the right to change the conditions of bail, keep him in custody, or whatever. Now, government seeks to suggest that they're doing something revolutionary here by amending the act to provide for a term of imprisonment of 5 years or a fine of $50,000 for breach of an offense under the new section 12A. Now, old section 12A is saying that you breached a term of your bail. Now, let's be honest. Somebody's going to breach a term on which bail was granted. So he's granted bail. He has to appear at the police station every Friday at 10 o'clock. He doesn't appear. He's told not to go in a certain area. He goes in that certain area. Do you think it reasonable that any court would even think of imposing a fine of $50,000 or sending someone to jail for 5 years for such an offense? Just the whole idea is absurd. Now, if you want to make an offense that is at least slightly reasonable, then I can see it. Now, admittedly, the judge has it, or magistrate has the discretion in terms of the fine or the term that he imposes. But what can the person have done in breach of his condition? That's all we're talking about. That would enable the court to send him to jail for 5 years. In all likelihood, the offense that he's charged with wouldn't attract a jail sentence of that amount. As the member for Bain and Grandstown said, get less time for possession of guns, one of the most serious issues that are facing this country today. And yet you're going to send him to jail for 5 years because he was in breach of a condition. It just demonstrates the fact that this bill is simply window dressing, making it appear that something substantial is being done by this government. There's so many other matters, Mr. Speaker, which are so significant and need to be addressed, and this government simply ignores them. It's as if they went in a hat box, pulled out a bill and said, oh, let's do this one. We got nothing to do. They got no agenda, so they just pick out some rather insignificant bill and ask us to deal with that. When we have these issues of freedom of information that was been discussed so many times since this government came to office, they've indicated how important that is, that it's essential that there is a Freedom of Information Act. Admittedly, there was an act which was passed by the previous administration, but it was well known and accepted that there need to be certain amendments to that. And yet what has happened? Nothing, other than they've drafted a bill, sent it for circulation, and now No doubt it won't be passed before the country kicks him out of office. There's just constant matters like that which need to be addressed, and we're going to be dealing with something like this. When we came in here last week, I think it was, on Wednesday, issues were made about serious matters of financial matters, all of which would come under Freedom of Information provisions, where the member for Fort Charlotte spoke about the BAMSI contracts, which were awarded, and in one instance, building itself burnt down. The building was not insured. And what has this government done? The government is anywhere, we don't know how much was lost on that contract, because the provision was the contract price was anywhere from 2.6 million to 3.25 million. So anywhere between there, and I wouldn't be surprised if they spent the whole 3.25, even though the building wasn't completed, and nothing has been done. Nothing. Do we just write off that amount of money and think that that's something that this country should forget about? The member for Cat Island had indicated in one instance that the contract had been insured. Clearly was not. And yet the building burned down over a year ago. We have not been provided with any information from the other side as to what the end result was. The contractor who was given the contract had indicated he's going to repay it. Nothing has happened. Then the minister talks of suggesting that he's not responsible for any cronyism. Well, I think he could only say that, Mr. Speaker, if he doesn't understand the meaning of the word cronyism. But according to the Wikipedia Encyclopedia, cronyism is the practice of partiality in awarding jobs and other advantages to friends or trusted colleagues, especially in politics and between politicians and supportive organizations. For instance, this includes appointing cronies to positions of authority, regardless of their qualifications. Merriam-Webster describes it as define cronyism, the unfair practice by a powerful person, such as a politician, of giving jobs to other favors to friends. So that's what we're faced with, and this government does nothing about addressing it, nothing about dealing with that issue. So they think the country should be satisfied that they continue to milk this country and do nothing about it. So when you have a situation where, in the instance of the building that burnt down at BAMSI, the contractor was a friend of the member for Cat Island. He's a general for the member for Cat Island. Now, what part of that is not cronyism? Cronyism is alive and well in this country, as demonstrated daily by this government, Mr. Speaker. We then have the instance of the contract being given to a former member of Parliament, cabinet minister, has no interest whatever in construction, and yet somehow you grant him a contract to build a 3 million or whatever the cost of the building was building. Again, if that is not cronyism, then I don't know what it is. Clearly, the Minister of Works doesn't understand what cronyism is, because he wouldn't have said that if he really knew the meaning of it.
He's only a lawyer. He did not put studying.
Then we have these instances, Mr. Speaker, that just remain unanswered. Why didn't this government start dealing with issues which are relevant, which are important to the people of the country? When you go and issue a nollie, again, to a friend of, a client of the Attorney General, by a acting attorney general. You have the member for Mical calling up the administrator in Mical, discussing a case which is before the court. It is all demonstrates on a daily basis why this government needs to be removed. Now, you know, in many instances, Mr. Speaker, they like to suggest, and I hear them mumbling over on the other side about, oh, the FNM do this, FNM do that. At some point in time, the members opposite need to understand this phrase, if it broke, don't fix it. Well, it is broke, so you need to fix it. You cannot continue to act in a way that is allowing the government of the country to continue to hand out contracts to cronies. Cannot allow it. We have every, and when you give it to someone, in addition, as I always understood, the Ministry of Works were obligated to send every contract out for more than $50,000 to bid. And yet here we have 5 contracts issued in BAMSI, 5 of them, and not one of them went out to bid. And we're supposed to be happy and think, oh, our Minister of Works, he wouldn't allow it to go out unless the right price for the people and the country was awarded.
Member for Montague.
Wondering,
Member-
Mr. Speaker, if
member
you
for
permit
Michael.
me to at least deny the fact that I never called any administrator about any case with which he had been dealing. Never had. And I want the member for wherever,
Montague.
Montague to know that I had never, ever spoken to the administrator about a case. What I did do, Mr. Speaker, and I said it before and I repeat it, there was an injured man, and I asked if he would allow him to see a doctor. That's my constituent, and I thought I was helping in a humanitarian way. Nothing to do with no case. I just thought I'd make that clear. Now, you could interpret whichever way you want. That matter, as far as I'm concerned, Mr. Speaker, is history, and these people like history. When I speak, I will deal with you.
Thank you, Honourable Member. Member for Montague.
That sounds like I should deal with the Mical when I'm standing up then, if I have that kind of threat thrown at me. Because it was Mical also who last week started talking about, oh, I'll give the contracts to my boys, no problem. I'll give it to a crony, and he thinks that's acceptable.
Member, very well. Member for Michael.
Mr. Speaker, and this, I'm not gonna follow up Montague, who has been deemed by some of his people to be a racist. I'm not gonna do that. I'm not gonna go there.
I wouldn't go there, Honourable Member.
No, I'm not
I
gonna do
wouldn't go
that.
there.
But I
I
want,
wouldn't go
Mr.
there.
Speaker, on the record, Mr. Speaker, I have said, and I repeat what I did say.
They'll throw anything.
When the matter with respect to BAMSI contract came up, I was asked what I thought about it. Mr. Speaker, and I want to repeat what I said here now, because I said it then, I'll say it now, and I'll say it tomorrow. I said that people who support the government has an entitlement to be assisted by the government like anybody else. Because, and I went as far as to say, because those who support us ought to be assisted, because hadn't it been for them, we would not be in power today. That's what I said. And they have a right to any assistance that this government could assist them with. They do it, and don't let me call Fletcher McIntosh's name in this house. I wouldn't do that. I wouldn't do that, but let them do the research and see who he support and how many contracts he got while the former administration was in place.
You just did.
I just throw that out. I got some more.
Mr. Speaker,
Member for Montague.
The member's so hard, he can't even get it out there.
well, there we have it. We have it confirmed. There's a difference between this side, Mr. Speaker, and the other side. We do not consider it an entitlement simply because somebody supports you to get every contract out there, and you deprive the other citizens of this country who do not support you from being entitled to that same benefit.
Who said that? Who said they were not entitled to
The member for Michael has just said that, unless he wishes to direct his mind simply to one aspect of what he said. If you turn around and you only got a certain number of contracts, you go and you give them to people who, as you said, they're entitled. They're entitled. They support us. So they're entitled to it. What about the other people out there? What about the other citizens of this country? When they're talking about, we believe in Bahamians, we believe in PLP Bahamians. That's what he's telling us. And if they think that's right, Mr. Speaker, no wonder this country can't move forward when we continue to have that kind of attitude displayed. Don't turn around and tell me that who did it or back there. I don't care, Mr. Speaker. It is wrong. And yet they still feel that they can continue with that kind of attitude. If this country is going to change, then we need to start at some point, because they're clearly not responding. They're not moving, changing anything. The days when you sit back and you simply give a contract to somebody because he supports your political party, those days should be gone. And if not, then the people need to kick them out next time so they won't try it again.
Members.
You remember calling us hogs over here?
You know,
No, you remember right from that same seat.
now, Mr. Speaker, I don't expect the other side to change. I don't expect them to change. Most of them are so old, you know, that you can understand why people call them political dinosaurs. But that's it. They continue in the same old way as if there's a question of entitlement. When are we going to change the way business is done in this country? Certainly not while they're in office.
I
Remember you-
tried hard not to, and I continue to.
Member for Cat Island,
I
Rumkey.
continue to remind members that I don't pick fights. I try to stay away from it. All right? But if I'm not going to run from any. Now, this member questioned the extent of my vocabulary as to what I understood. I don't know the meaning of the word colonialism, and he then went to the Wikipedia encyclopedia. And then he, you see, I'm not going to question what he interprets the meaning and what his quotations. But he did introduce another word. He introduced another word. Another word was nolly. You say something nolly? You just said something nolly? Nolly Musquet? I wonder what's the difference. You know, there was a gentleman in this country. His name was John Lester. John Lester.
Yes.
He sat in a magistrate's court in the Senate building, right down there. Documents are typed. Something happened in that court. I wonder where there was a nolly. And I'm satisfied that that member could speak to me. I'll say no more right now. I knew the gentleman well.
Who was the lawyer for that?
Right.
John Lester?
The member who's speaking now,
Couldn't be his man.
John Lester, he's a Guyanese. Very good friend of mine. I've appeared before him many times.
Thank you, Honorable Member. Member,
As I said, Mr. Speaker, I don't like picking fights, but I'm not afraid of any. Once started, I wonder how he would describe whether that was a nolly or something else. Because I'm trying to understand the meaning of nolly.
thank you, Honorable Member. Member for Montague.
Mr. Speaker, it's evident that the member for Cat Island does not know a thing about what he talks about. Nothing. Nothing. And he endeavors to make some offensive remark which he thinks refers to me. And I can tell you, there is not a shred of information that he has come out of the member for Cat Island's mouth that has anything whatever to do with this member. You know, it's funny how members opposite always like to jump up and start talking about you did this or you did that.
Point of order, Mr. Speaker.
Point of order, member for Cat Island, Rumkey, in San Salvador.
The member denies that the matter I spoke to involves him. I never said it involved him, you know. I said he could tell us about it. That's what I said, right? And he seemed to know something about it. He seemed to know something about it because he's able to say it was not about him. One thing that he has impliedly told us that something did happen, but it didn't involve him. Well, what I think it bears out, what I say, that he knows that he could probably help us as to what happened and tell us about it.
Thank you, honorable member. Member for Montague.
You know, Mr. Speaker, you always say when you throw a rock in a pack of dogs, the one that screams is the one that's hurt. Now, I'm not referring to members opposite as dogs, but you get what I'm talking about. All right? Now,
Member, I tell you what, let's pause for a second. Member for Montague, no, we'll fix this. Member for Montague, I understood exactly what you said. You said it in jest. You clear, no, member. He said it in jest, and he said that he's not calling members opposite that word. However, it's still taken in offense. And so the chair would prefer you not to use that analogy and to take it back. The chair would prefer, in the interest of civility in this honorable house, the chair would prefer that you do.
Mr. Speaker, I thank you, Mr. Speaker. I had no intention of heading there again, and the members opposite seem to bring it up. So I have no intention of going there, Mr. Speaker. Thank you.
So you,
I would be surprised.
member,
He called us that. Dogs. He called us that.
no, he didn't,
Yes,
didn't,
sir.
honorable member.
Yes, sir. He said when you throw a rock among dogs, he's speaking figuratively.
Yes?
Then it wasn't you, all right?
No.
I'm calling
Don't
you
say
dogs,
that to me.
okay?
You can call me anything you want to call me. Call me anything you want to call me. You shouldn't be talking in here. Oh, I'm fenced in?
Members,
Oh,
members,
okay.
both members.
What the hell do you mean I know exactly?
Members,
You mean I know exactly
members,
what he meant?
member
Yeah,
for
he meant
Montague,
dogs.
members,
That's what he meant.
members,
He can't help himself.
members. We're not going to allow the House to descend to this level. Before this happens, the chair will suspend. The chair will suspend for a period. Member for Montague, take it back. Take it back. Members obviously take offense to it. The chair would prefer you to take it back and move on.
Take it back, Mr. Speaker. As I said, I didn't direct it to anybody, but if somebody takes offense, then I certainly withdraw ever mentioning the word.
Thank you, honorable member. Thank you. You may continue.
The surprising thing, Mr. Speaker, is the member for Cat Island is so quick to jump up and try and run with some red herring and not address the issues which were directed toward him with regard to his report on the finances in BAMSI. He has a general of his who was given a contract for $2.6 million to $3.25 million. The building burnt down. The country has not seen $1, and we haven't had the first piece of accounting from the government, and the member in particular.
Member for Cat Island, Rumkey.
Speaker, I'm not there. I've heard him the first time. I've heard him time and time again. But I don't think he ought to set my agenda. I think he will get his answer. I thought I answered sufficiently before. They're not satisfied with the answer.
You didn't give us
And
any
at the
answer.
appropriate time, I will, but if I want to address the matter again, I will. But he could continue to beat himself up about this matter. And he said, I keep jumping. I'm not jumping up. I listened to him, you know. I listened, but there's only so much we can take. He continues to pick a fight. I was avoiding the fight. I was avoiding it. And he continues to insult us on this side. He continues to paint this side as some people, some bunch of crooked Negroes.
You know? I say that. That's he paint us. Black people, right? That's he continues. Nothing we do, and I don't expect to be able to please the member. He's in opposition to me. All he's going to do is see me through the lens of opposition. But when he's going to attack my integrity and character, I need to touch him. I need to touch him. And see, Mr. Speaker, I know a lot about a lot of people and a lot of things, but I don't go there. But the moment you intend to deal with matters, I don't try, right? Well, whatever you know, right? What I'm saying, I will, Mr. Speaker, this member continues to do it. And all I said, Mr. Speaker, I just mentioned some things that he may know about. I didn't say he was involved. He acknowledges about those things, but he distanced himself from it.
Thank you, Honourable Member.
And I'll say no.
Thank you, Honourable Member. Member for Montague?
You have free sanctions.
Speaker, I don't know whether the member of Cat Island is suggesting that I was, what's the word he used? That I am questioning his integrity by stating that the building burned down, the contract was not insured, the government is out of pocket anywhere from 2.6 million to 3.25 million. We have never received one piece of evidence from that side, Mr. Speaker, which would indicate any information with regard to it. We had a struggle to get the actual contract, or it wasn't even a contract, was the payment schedule for that property. That's all that we have received. His memory failed him at one point. He said, oh, we'd given us all the contracts. That's the only thing we've given, nothing else. And we got 4 other buildings, and I am sure that all of them, I would not be surprised if a number of them are granted to cronies as well. So if I am questioning his integrity by saying he gives contracts to cronies, he does in accordance with this understanding of what the word means. He threw it at the member for Fort Charlotte, suggesting he wasn't giving contracts to cronies. But clearly, in any definition of the word, it's exactly what they have been doing. And at what point does that stop, Mr. Speaker? Now, Mr. Speaker, when we look at as I'm saying, I really don't know what it was that what it was that the government was suggesting that they have provided us, or what the member for Cat Island is suggesting that they provided us with regard to these BAMC contracts. The member wants to turn around and say, we got value for money. Well, how do we know? We don't know what they got. Certainly got a burnt down building, but I don't know what value they got. Now we're talking about the one given to the former cabinet minister. What does he know about construction?
Member for Montague?
Yes, Mr. Speaker.
I think you should move on. I think you've dealt with that quite sufficiently.
You've had enough of that? Well, we could go on forever, Mr. Speaker, on those matters, it's true. What I was, you know, I will give you a quote here, Mr. Speaker. This is from a member opposite. And he is quoted as saying, crime and the fear of crime has never been greater. The Bahamas has never felt as unsafe as it is today. Criminals have never been bolder. There have never been so many guns on the streets. Never. Now, I don't know if any of you know who those words are attributed to, but they are quoted as having been said by the mover of this bill. the member for Bain and Grantstown. And you know when that was said, Mr. Speaker? Of 2011. 2011. And if those words don't apply today far more than they ever did in 2011, then devil is a liar. No, this is a quote in 2011. Then you made grave objection in 2011. They took grave exception with the government at that time in its criminal initiatives at that point. They criticized electronic monitoring, closed-circuit television in key areas of New Province, appointment of additional magistrates, Supreme Court, Court of Appeal judges, a gun court, the technology for the police department, more police recruits. That was all regarded as a waste of time. Nothing was going to happen. And what have they done? Exact same things. That's all that they've done. There are really no new initiatives, other than we talk about urban renewal and think that that is going to solve the crime problem in this country. The information which the member for South Eleuthera gave us with regard to initiatives within the court system that have been taken by this government certainly show that there have been changes, there have been initiatives, but whether that is enough to change the direction in which our country is headed at this time, I suggest that it is not, Mr. Speaker. You're getting dates now for court matters in 2018. 2018. How can we say our judicial system has been fixed? To any degree, 2018, it's unheard of. So the fact that you may have so many murder trials completed in a year really has had only a very, very marginal effect on the system. There is so much more that needs to be done. So I would suggest that before government brings up more of these bills, such as the one that we're debating here today, they need to consider far more important matters which need to be addressed by this government. And so when I talk of freedom of information, Mr. Speaker, it is outrageous that this country is at the point it is today. We heard it was a year or so ago, the U.S. State Department was objecting to the way in which contracts were issued in this country. And that is continuing to be the process. You go and you hand out all these contracts in BAMSI, you give them to friends, and according to Mike Cal, you're a supporter. They're entitled. Until we address that and change that, then this country is not moving forward, Mr. Speaker. But as far as this bill goes, Mr. Speaker, I have no objection to the bill itself, but what I would question is whether it is really going to achieve any benefit, any real benefit at the end of the day. As the law stands now, you can bring in someone who's out on bail, and you can change the terms of their granting of bail. So to start talking of imposing a fine of $50,000 or 5 years in jail, it just does not make sense in the scheme of things. Man go to jail for possession of a gun for less than 5 years, and yet you're going to send him to jail for breach of a term on which bail was granted. That's absurd. So, Mr. Speaker, I thank you, and I would like to thank again the constituents of Montague for giving me the privilege of representing them in this House, and I thank you.
Thank you, Honorable Member. As many, Chair recognize Honorable Member for Michael.
Thank you very much, Mr. Speaker. Mr. Speaker, I'd like to begin by saluting the people of the Macau constituency for their confidence and support. Lo, those many years in which I have served in this place. And Mr. Speaker, I don't know how long my political future will last, but I do know that there is an element of confidence that I have been given, and I don't take it for granted. Every day, Mr. Speaker, I try hard to help somebody, whether from my constituency or not. I believe that that is the purpose for which God has given me this opportunity, to help people in any way I can. And Mr. Speaker, I pledge I will do so as long as I am able. As long as the cords of my political life shall lengthen, my job will not be complete until I would have tried hard to wipe tears from every eye. And so, Mr. Speaker, with that said, I want to say thanks again to Acklands, Crooked Island, Meg Warner, Inago, and Long Key. And Mr. Speaker, I want to, if you would permit me, to invite the people of our country to Salina Point homecoming this weekend. This is a wonderful southern end of Acklands, and they are having homecoming, and I'm hoping that some people from elsewhere will show up in support of their annual efforts. Also want to say to the people of Salina Point and South Acklands, Mr. Speaker, that the matter of the Salina Point Road is presently being discussed by the Cabinet, and it should not be long now before the matter goes to contract for the beginning of that long-awaited road from a long time ago. But Mr. Speaker, if I could just mention that a few years ago, the contract was awarded by this government in 2004-05 for the, or 6 or 7, sorry, for the construction of the Salina Point Road. When the F&M came to power in 2007, under their cancel review policy, they stopped the road. I just want Acklands people to hear me. They stop it. And it was stopped for 5 years. Now, Mr. Speaker, I said in this place before, I didn't mind if they stopped it because they wanted to give it to somebody else. But they stopped it altogether because Salina Point people were heavily supportive of this government, and they chose not to ever renew that contract for the 5 years they were in power. And so the roads went from bad to worse to worse. And I thank God I see a glimmer of hope on the horizon, because they left the country broke, very broke. And so even though we might have wanted to do it, there was very little or no money with which to do it. So we had all issues, but hopefully in the next few weeks, tractors and bulldozers and whatever else they use to build roads will be running. Mr. Speaker, I also want to say this. The member for Montague talked about cronyisms or cronyism. Mr. Speaker, you be the judge. You talk about giving assistance to supporters. Mr. Speaker, what do you call when that government, just a couple of years ago, gave their supporters, when they stopped, review, and canceled the straw market? They took it from somebody who they believed supported the PLP and gave it to one of their supporters. What is that, Mr. Speaker? I will not be the judge on that. I want Montague to be the judge on what he called that. I also want him to be the judge on what he called this, the Sandilands Rehabilitation Center. Who built that? I want him to tell me whether if he knew if it did not support their side. That ain't cronyism for them. Not at all. Only PLPs would be cronyism to give its supporters any jobs at all. I ain't finished. When I finish, you could respond to all one time.
Member,
Mr. Speaker, I'm not yielding. I have two more, and then I want him to respond to all. Mr. Speaker, the other one I want to mention, the extension.
Member, if the member stands on the point of order, I'm
Mr. Speaker, I
obliged.
reluctant to yield.
I'm obliged.
Let's oblige.
Member for
Thank you, Mr. Speaker.
Montague?
The member for Mykal was beckoning me to respond, Mr. Speaker. I couldn't disappoint him. But there's a clear distinction, Mr. Speaker, in what we're referring to. Contracts for a building generally go out to tender. It's obvious that somebody is going to, who gets a contract, may well be a supporter of either party. Either party. But the fact is, it goes out to bid, and the price that one accepts is, in more cases than not, the lowest price. But there is a bid process. So obviously somebody, and may well be a supporter, is going to win the contract. The other side, Mr. Speaker, they seem to feel we don't have to go to bid. We just give it to somebody who supports us, and they are entitled to it. That is the major difference, what I'm talking about, Mr. Speaker. And obviously, the member from Mykal doesn't understand that.
Thank you, honourable member. Member for Mykal.
As much as I know, Mr. Speaker, there may be some negotiated positions on both sides of the political aisle, especially when speed is of the essence. When an emergency matter is taking place, sometimes you negotiate with people in order to get the work done very quickly. That happens on both sides. But Mr. Speaker, I want him also to tell me what he considers all of these that I am mentioning. If he says that no person of the opposite political persuasion could qualify if it went to bid, tell me what the end result is. I'm not concerned about much. The extension to the new hospital, who built that? You think only F&M's bid it? No, but they got it. I don't know how these things work with them. Mr. Speaker, quite frankly, it seemed to me that when we speak to supporters or people who perceive to be supporters getting anything from the government they support, it's cronyism. Mr. Speaker, I don't believe that. I believe that they have a right to the same assistance as everybody else. And if it turns out that they are a supporter, we make no apology for that. They have the same right to a job as anybody else if they are qualified to do it. But I guarantee you, Mr. Speaker, if it was an F&M who got the job at BAMSI, they wouldn't say a crack. But they think they may be a supporter of the government. And so they're raising all kind of trouble about it. Make no apologies. Well, he only came to say what he says because we are hogs. He don't want to hear it from us. Mr. Speaker, let me turn to this bill and the effect of it. Mr. Speaker, as you know, I know perhaps lawyers will appreciate it more, perhaps, than laymen. But, Mr. Speaker, everyone, be he woman, man, boy, girl, if they're charged before the court, they are entitled to be considered innocent until proven guilty. And, Mr. Speaker, in most cases, bail is granted to an accused person pending the outcome of his or her case.